Right, welcome back. Good afternoon. On this other segment by covering human rights issues in general, and just really um, having an overview on the some of the issues that are impacting our day-to-day lived experiences, but also requires a legal context. Again, in a malleable and simple tone that um, ordinary people like myself and others um, can sort of digest and trigger conversation, practical conversation, constructive conversations that actually allow resolution, or at the very least be able to mitigate or eliminate or reduce the necessity for that or the some of the causes that lead to the human rights violations in those areas. And so, among those is a text that I wrote that is called, well, rather collated or reproduced, called the Global Magnitsky Act. And it's a one-stop reference for key global Magnitsky statutes and under the Global Magnitsky Act. So, just for as a proviso, it's important to clarify that the statutes in the text are replicated in their entirety without changes, and they're a reference source for readers, researchers, for primary academic research or related use of the legislation. It's not an analytical text, although I think it's really important to have one that analyzes that. It's not an analytical text that takes a view one way or the other, and neither does the author claim credit for the statutes, but rather it was, I think, a necessary collation and compilation for easy comparative reference and access for all. Of course, I would like to extend gratitude to those who provided public written reviews analysis, which collectively form the basis for this right. I think that will be take two. So I'm now discussing the Global Magnitsky Act, which is a one-stop reference for key global Magnitsky statutes, and it's not an analytical text. It's just it's not an analytical text. It's just a collection of materials, legal materials and statutes all over the world, globally, that form a reference point for this growing area of law, with an aim to have a more coherent and united approach. I would like to extend gratitude to those who provided public written reviews, which form a basis for this growing area of international law in a rapidly changing world. Once again, much love and gratitude to those who have been a source of inspiration, especially during the lockdown era of 2020, whilst I was compiling this text and many others. So just an overview, the Global Magnitsky Act was initially passed in the United States to deter individuals associated with human rights violations. And the U.S. State Department has deployed the act against specific individuals all over the world. And as a general background, so J. Magnitsky was a lawyer who claimed to have uncovered large alleged nefarious activity. And this is a quote. I'm quoting some of the references here describing the background of the Magnitsky Act. And it goes on to say that whilst working for Hermitage Capital, a firm based in London and run by the US-born financier Bill Browder, that's when he claimed to have allegedly discovered this nefarious activity, and he was arrested but refused to withdraw his testimony, and is reported to have died in 2009 after alleged mistreatment in jail. That's the general sort of factual, or at least reported factual alleged background of some of the genesis of that led to the sort of campaign to have sanctions imposed and subsequently led to the Magnitsky Act. So Bill Browder then started a campaign to have sanctions imposed on the officials involved, to get the officials banned from visiting the US and using the financial system. A Magnitsky Act naming the person involved was passed by the US Congress, I think in 2012, and was later broadened to become the Global Magnitsky Act, applying to gross human rights abuses anywhere. Other countries, including Canada, Lithuania, and Estonia, have introduced their own version of legislation. There's the US version of the Act, passed by the 114th Congress in the second session, and I think this is verbatim S.284 in the House of Representatives when it was sort of discussed, and it was referred to the Committee on Foreign Affairs in addition to the Committee on the Judiciary for, I think, around April 2016, as the reports appear to indicate, for a period to be subsequently determined by the Speaker in each for consideration. And the Act, just briefly, was to impose sanctions with respect to foreign persons responsible for gross violations of internationally recognized human rights and other purposes, and it was recommended to be enacted by the Senate and the House of Representatives in Congress, and it was cited as the Global Magnitsky Human Rights Accountability Act. And it's detailed, it's available in the book if one chooses to go into the details. But essentially, it triggered almost other acts being enacted in many parts of the world, such as the UK and the EU. In the case of the UK, there was increasing pressure from the UK to follow suit, and various pieces of legislation came before Parliament in the form of private members' bills and amendments to government bills. And although Magnitsky did not appear in the official titles, and I think they did not refer to Russia, or at least the country in which Magnitsky is reported to have originated. The Magnitsky amendments to UK legislation were broadly welcomed. However, two major pieces of legislation had Magnitsky elements added to them, such as the Proceeds of Crime Act 2002 and the Sanctions and Anti-Money Laundering Bill, now the Sanctions and Anti-Money Laundering Act 2018. The Criminal Act, Finances Act 2017 amended the Proceeds of Crime Act 2002 to expand the definition of unlawful conduct to include gross human rights violations and abuse, But after opposition, government amendments, the Sanctions and Anti-Money Laundering Act 2018 included gross human rights violation as a reason for imposing sanction on a person or an entity. And so after the passage of the 2018 Sanction Act, the UK government said it will bring forward more detail on Magnitsky sanctions in the form of secondary legislation using the powers in the Act. The UK government announced the first new sanctions using the Sanctions Act in July 2020. The House of Lords Library quoted verbatim here and makes reference to the Act below, and it states, the UK also has a legal framework for imposing Magnitsky-style sanctions. The Sanctions and Anti-Money Laundering Act 2018 created a domestic legal framework to allow the government to impose new sanctions or to update or lifting existing ones after the end of Brexit transition period. And specifically, Section 1 of the Act gives the Minister powers to impose sanctions on people and entities by making sanction regulations if the Minister considers it appropriate. And sanctions regulations can only be made for the purposes of complying with the United Nations obligation, another international obligation to fulfill one of the discretionary purposes listed in Section 1 of the Act. And this includes, among others, I just briefly mention them, but won't go into details for obvious reasons, in interest of time, etc. Is to provide accountability for or be a deterrent to gross violations of human rights, or otherwise promote compliance with international human rights law or respect for human rights, promote compliance with international human rights law, and promote respect for democracy, the rule of law, and good governance. There's more detailed information, but I would just quickly say that in the book, the sanctions can be imposed using these powers include, among other things, financial sanctions, travel, immigration sanctions, freezing of funds, and preventing others from receiving financial services. And the UK government in 2020 used powers in the 21 Act to make the Global Human Rights Sanction Regulation 2020. Other countries also have followed suit, such as Canada, the EU, which I'll probably look into more details, and some countries in Eastern Europe. So what appears to have happened is that what happened to certain individual who claimed to have uncovered nefarious activity and as per Bill Browder claims to have suffered violations of human rights, has led to now a more broader global legislative mechanism to counter not just governments but individuals allegedly involved in such activity by mainly, I should say, Western governments, and I think most institutions, human rights campaigners all over the world would welcome that as yet a small step towards curbing gross violations of human rights. And so we will go into detail into as down the road, but if it helps, there are other countries that have adapted such, at least mirrored the Magnitsky Act in Europe, and I will deal with them step by step. But generally, the reference, the publication is entitled the Global Magnitsky Act, a one-stop reference for key global Magnitsky statutes. We shall pause there, and then when we come back, we will be looking at two other important subjects regarding, again, human rights issues, the International Criminal Court, and the reverberations and implications arising from that, looking at in a more specific case, and how that has impacted the democratic credentials of that case in that specific country. Thank you, and we'll be back soon.